The complexity of the United States legal system is beyond the boundaries of the mere sum of its concepts. It is the interactions of these concepts that create our legal reality. Despite their centrality, common conceptual misunderstandings and misrepresentations have complicated law into a nest of chaos, manipulation, and controversy. Natural law theory is a philosophical view used to analyze our legal system. However, it contains misleading and inaccurate depictions of the connection between law and morality. This connection is important and requires reformed understanding and representation to advance institutional inequality, injustice, and instability. I will discuss the connection between law and morality and how its misrepresentation of simplicity in natural law theory is insufficient in its guidance and accountability of actual law. The nature of law is a philosophical theory where law's very essence is the differences, interactions, and dependencies of its concepts. Moral theories are very important in legal discussions because of their independent ability to guide behavior. Morality is a subjective opinion of right and wrong that carries no universal standard. Moral philosophy, on the other hand, is a universal system of broad moral principles that guide and govern society concerning relative behavior, fairness, and responsibility. Natural law theory believes that law is subservient to universal moral normity, or moral philosophy, in terms of legal validity, source, and legitimacy. Natural law theorist St. Thomas Aquinas describes legal rationale as intrinsic to moral authority, which is rules ordinated to the common good. The theory very simply and wrongfully represents law's connection to morality through the objective and equal standard of moral philosophy. As we will see, this is not the actuality of legal practice. Morality is, nonetheless, theoretically and empirically necessary for analyzing and advising legal institutions. Law's multidimensional connection to morality is shown through individual ethics, societal values, and principles of justice. It is a building block for legal rationale and application and is embedded in all legal decisions. These connections, however, are different from those described in natural law theory. Natural law theory's neglect of the circular interactions of morality and law is one example. In addition to law's dependency on morality is morality's dependency on law, seen through dynamic evolution and political consensus. Law's effect on the dynamic evolution of society manifests in the ongoing changes of moral values and behaviors. A political consensus created by law regards universally accepted policies independent of the subjective moral values of its people. It allows the citizens, however different, to come together in agreement about how to coexist with each other without authoritative moral theory. These consequences of law are not dependent on moral philosophy, but they are connected and influential to morality. That being said, what is required is an alteration of natural law theory that properly defines and represents law's connection to morality within its natural complexity. The problem of natural law theory is its portrayal of and dependence on objective morality reigning over law. Such misrepresentations, like the neglect of law and morality's circular connection, destabilize the institution by giving false accounts of its conceptual interactions. This produces inconsistent and manipulable rules demonstrated by the fallibility of the United States legal system and seen throughout time by inconsistent and contradictory decisions involving moral issues. Illustrating this are the opposing decisions concerning legal human rights seen in Supreme Court cases Plessy v. Ferguson and Brown v. Board. The result of Plessy v. Ferguson was in support of the constitutionality of segregation laws. Meanwhile, the results of Brown v. Board found separate but equal laws to be unconstitutional. These cases represent the overwhelming power of judicial interpretation and its inconsistencies. Their contradictions would cease with a coherent understanding of law's connection to morality. To these examples, natural law theory's belief in a guiding objective morality is ignored in actual application, or else each decision would be uniform. It seems the connection between morality and law in actuality is dependent on individual interpretation. Natural law theory's inability to be applied in reality results in disorder and controversy because the understanding of morality and law's connection rests on misrepresentation. Law is not elementary, morality is not universal, and their connection should not be reduced to distorted simplicity. Objecting to this line of reasoning is the notion that the argument itself is unnecessary because it supposes falsities about the reality of the United States legal system. Understanding the true connection between morality and law is needless because they are systematically separate and laws are nonetheless stable, obeyed, and binding. What authorizes and guides legal decisions is the precedent and text of the law. Furthermore, societal obedience demonstrates institutional success. Legal philosopher H.L.A. Hart's system of primary and secondary rules is a theoretical example of stable regulatory and procedural laws that are indifferent to morality. Primary rules give rise to the obligations for coexistence, while secondary rules confer powers and govern those primary rules. Hart's union of laws is seen in actuality and fundamentally separate from morality, therefore rejecting the necessity of the argument. If these laws are indifferent to morality, it can be argued that they all are. The laws may address issues of morality, but they are separate in terms of validity, authority, purpose, and application, meaning that laws and morality need not align with each other, and legal decisions do not require moral influence. Therefore, under this objection, natural law theory itself fails, and so do all grounds for the rejection of its connection between law and morality. Responding to this objection requires an acceptance of inherent moral influence on all humans and human institutions. The sense of good and bad and the desire for civil coexistence is foundational to political society and therefore law. Even if human variation causes major individual moral discrepancies, its mere existence generates its universal influence. Undeniably, there is moral influence on the creation, application, and revisions of laws and their dependencies on societal values. Even after legislation, humans must interpret and apply legal text and tradition with a great deal of moral influence. Ignoring the central role of morality in human and political processes is illogical, irrational, and leads to critical problems like inequality and injustice. This objection is yet again trying to simplify the complexity of law by saying the law is individual from its concepts. Philosophical theories like nature of law and common law further discredit this objection. As previously mentioned, the nature of law assumes legal features such as morality are possessed by the very core of law itself and therefore inseparable. Common law argues that the interrelation of legal concepts is proven through their continuity within judgments. As supported by these theories, one cannot separate the law from its principles. The identity of law is in itself intertwined with morality because it concerns an equal, general, and just coexistence of political societies. We cannot escape morality within ourselves or our institutions. In closing, it can be said that the principles of law are complex in their interactions. Proper understanding and representation of such complexities, specifically the connection of law and morality, are necessary. Natural law theory fails to adequately illustrate such connection because it mistakes the roles and influences of each component. The theory's misrepresentation affect the operations of actual law, guiding it away from stability and union because of its chaotic management of moral issues. One must consider, however, if morality really is subjective. While it may seem obvious, I fear this concept, especially in the face of law, is not so simple. Consider the theory of moral realism as opposed to moral subjectivism. Moral subjectivism, the theory I have proposed in this argument and used to define morality, assumes moral standards are relative and universally inapplicable. In opposition, moral realism suggests the existence of objective moral facts that guide us, independent of individual subjectivity. If this theory is true, then it seems that natural law theory is, in one way or another, correct in its representation of the connection between law and morality. Therefore, the argument provided, founded in moral subjectivism, is done away with. If this is the case, it seems that our actual legal problems are of a different nature, perhaps our nonconformity to such moral authority.